State versus Ian Leisman, 20 CR 165.
Yes, sir.
Okay, you're in court. Let me see what we got here. It's a motion to revoke probation has been filed in this case. You have the right to have an attorney represent you in this matter. If you can't afford to hire an attorney, I'll appoint one. Do you know what you're trying to do with regard to an attorney?
No attorney, sir.
Alrighty. Somebody give him a waiver form then.
But
You have the right to hire your own attorney. Like I said, if you can't afford to hire one will be appointed, no cost up front to you. If you choose to represent yourself, you have to follow the rules of evidence and procedure just as if you're an attorney. There's no special treatment. Are you going to influence any alcohol or drugs right now?
no, sir.
Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. If you've reviewed the form and want to waive it and proceed today, representing yourself, you can sign it at this time.
This is something way more dangerous. A real defendant deciding, nah, I don't need a lawyer, in front of a strict probation judge who literally controls his freedom. Today's case, State versus Ian Leisman, looks simple on paper, a probation violation hearing. But what makes this explosive is what's at stake. 6 months in jail, instantly activated, if things go wrong. And spoiler alert, things go very wrong. Probation is basically jail with better lighting. You don't get bars, but you still have rules, deadlines, and court orders you must follow. Miss one, ignore one, forget one, and the court can yank that freedom back like it never existed. And today, this defendant doesn't just forget paperwork, he forgets strategy, timing, and the single most important rule of court. Never fight the system without someone who knows the system. Watch closely how the judge tries to protect him from himself, how the probation officer quietly loads the case file, and how every word the defendant says actually digs the hole deeper. Because this hearing isn't about money, it's about compliance. And once the judge smells disrespect for probation, the vibe in the room changes fast. So buckle up, because this is what happens when confidence meets courtroom reality.
Looks like you've signed it. I'll find that you've knowingly, willingly waived your right to an attorney. I'll accept that waiver. I'll allow you to represent yourself. You understand you have the right to contest the allegations. Do you have a copy of the allegations, by the way?
No, sir. On the probation violation?
Yeah.
I believe it was for the remaining payment of the probation, because that was
I also failed to provide proof of obtaining drug and alcohol evaluation. Those were the allegations.
to do which one?
We'll bring you
The drug and alcohol evaluation?
Yes.
Okay. Alrighty. I did not do that unless I had done it with and sent it to Chris before, but yes, sir.
All right. Well, we're going to bring you a copy of those allegations here. All right. You understand? You have a copy of those in front of you, the affidavit alleging the violations?
No, it was the wrong paper. He's grabbing it right now. But I understand, sir. I do believe that I had forgotten to. The last time I talked with Chris, I do believe he had said that, and I had forgot about it and just thought it was payment. And
right here is the moment most viewers underestimate. When the judge jokes, the idiot that represents himself as a fool for a client, that's not humor, that's a warning. Courts aren't casual conversations. They're structured battles with rules, burdens of proof, and legal leverage. A defense attorney doesn't just talk, they frame facts, object, negotiate sanctions, and protect the record. By signing that waiver, this defendant didn't gain freedom, he lost armor. Now every answer is raw, emotional, and legally unprotected. Notice how the judge carefully explains procedure, evidence, and consequences. That's the court giving him every chance not to self-destruct. But self-representation almost always turns hearings into confession booths instead of defense strategies. Most people think being honest is enough in court. It isn't. You need positioning, mitigation, and leverage. A lawyer would already be planning alternatives, short jail sanction, extension of probation, treatment options, or delayed ruling. But this defendant just stepped onto the chessboard without knowing how the pieces move, and the clock already started. All right, well,
let me go over your rights with you. You have a right to contest the allegations that you violated probation at a hearing in an open court. It's the state's burden to establish a violation by a preponderance of the evidence. You have the right to present testimony of witnesses and other evidence on your behalf if you want to. If a probation violation is established or admitted to by you, I can continue, extend, modify, or revoke your probation. I could require you to serve the underlying sentence. You understand all the possible consequences?
Yes, sir.
Do you understand all your rights as I've explained them?
Yes, sir.
All right. It's alleged that you failed to make payments as required on your court costs, fines, as ordered by the court, and that your last payment was back on November 5th of 2021, and now you have still have a balance of $418 to that allegation. Do you admit or deny?
That I paid that up in full. Whenever I paid that, I believe it was this last week or the week before, and then scheduled for the court date for today.
Is it paid up?
The prior, I had made made arrangements. My mom had come over and to the court and paid everything remaining because I had moved down to South Texas, and then but they had added more charges, and then but the drug evaluation part, that I had forgotten all about that. But I mean, there's no record of like I have not been in trouble or, you know.
This is where the judge drops one of the most important lines in criminal court. Probation is your sentence in the free world. People hear probation and think second chance. Judges hear probation and think conditional freedom. Every condition is a contract: payments, evaluations, reporting, travel permissions. Break one, and the original jail sentence wakes back up like it was just paused, not erased, and notice the tone shift. The judge isn't angry yet, he's instructional. He's reminding the defendant that probation isn't optional homework. It's monitored behavior. Courts care less about excuses and more about patterns. Did you comply? Did you communicate? Did you respect the process? Here's the scary part. Probation violations don't require proof beyond a reasonable doubt. It's only a preponderance of evidence. Basically, more likely than not. That means the state doesn't need perfection, just enough consistency to show the defendant didn't follow orders. And once that threshold is crossed, the judge's toolbox opens wide: extend, modify, sanction, or revoke. And today, revocation is quietly creeping closer.
Let me go through this here. So you're saying your mom paid off your fines or whatever? It's paid off?
Well, and originally she had come up here to pay them. She paid everything they had on file, and then they had added that last $418 after she had come here to pay.
So the balance is $418 still. Is that correct?
No, that was paid last week or the week before.
Can somebody just go look?
We don't know.
We have no way of looking now. So let's skip that because
She said if it went to collections and he paid collections, we haven't been able to get it from them.
it may have went to collections. Let's just skip over to the next one. It's alleged you failed to provide proof of obtaining a drug and alcohol evaluation as ordered by the court. To that allegation, do you admit or deny?
I admit I did not do that.
Okay. I'll find that you, Mr. Marcinski, right now the court has no way of checking into any of this. I think it's been sent to collections is what I'm being told. So they don't know what's been paid, what hasn't been paid.
And if he has a receipt.
Yeah. Okay. Are you fine with skipping over the payment, Mr. Marcinski, at this point?
Well,
I'm not going to have a way of finding on it one way or another anyway, Miss, what I'm telling you. Nobody knows.
it appears to me that he is stipulating as of the date of this affidavit, he had not paid it. So the fact that he paid it 2 days ago or a week ago doesn't alleviate the fact that he committed this violation.
Well, that's okay.
I'm not going to contest that he hasn't paid as of today, but it would seem to me that as of the time of this PV affidavit, that amount was still
it's all
outstanding.
academic. I don't put people in jail for not paying their fines usually anyway, so.
I understand that.
Now watch how the case pivots. The defendant tries to defend himself using logic that feels reasonable. I paid, my mom helped, I moved, they added charges later. But courts don't run on vibes, they run on records. If the system can't verify payment at the time of the affidavit, then legally, the violation still exists. But here's the twist, even strict judges usually don't jail people for money alone. Debt can be fixed. Time can't. So the real danger isn't the $418, it's the drug and alcohol evaluation. That's a behavioral order. That's compliance. That's rehabilitation. When a court orders treatment and someone ignores it, judges interpret that as rejecting the entire purpose of probation. So while the defendant is focused on receipts and timelines, the court is focused on attitude and follow-through. This is where self-representation quietly fails. He's arguing the least dangerous issue instead of the most lethal one.
I'll find that you've knowingly, willingly waived your rights. I'll accept your stipulation as to the second violation. I'll take the first one under advisement until stuff can be sorted out. I'm just not going to get into that right now. It's not really necessary. State's recommendation.
Judge, I may defer to Chris on this one. Looking at my file, we're a little light. All I see in here, my last notes in this file were when I offered Mr. Leesman a plea from the felonies that Kerwin had charged him with to a misdemeanor. The very next thing I have is the PV affidavit, and then my most recent document in the file shows a no bond warrant for his arrest. So obviously that at some point was lifted because he's bonded out and sitting in front of us.
I don't think so. I think he had us put on the docket and showed up. I think the warrant's still outstanding is what I'm told,
Or
Okay.
as far as we know. So
So I would probably ask Chris what he thinks is appropriate at this point. If the case is paid in full, my primary cause for doing what I do is to try to get these folks into drug and alcohol treatment to help them get over their addictions. And it sounds like even as of today, that hasn't occurred in this particular case. And I see now that 3 years, almost 4 years later, I don't know what the benefit of that is, but there has to be some consequence to the violation. I mean, pretty much just disregarding of the probation. So I think at this point, Your Honor, I would probably request a sanction and then for the case to be terminated if it has indeed been paid in full, which I'm not contesting based on his statement that it has been paid. I would also ask the court to maybe ask Chris Hollis what he thinks is appropriate, at least as far as the sanction, and he may be able to even educate us about the payments and other things.
Your Honor, Mr. Leesman was on probation for almost a year, and he was on call-in reporting because he was a resident of Texas. Last time I spoke with him was on February 8th of 2022. And I informed him that he needed to come to Kansas so he can sign an extension of his probation due to the fact that he had not completed his drug and alcohol evaluation. And he still had an outstanding balance of $418. He told me that he's not going to make the time to come to Kansas and that if I need to file an affidavit, then just go ahead and do it. And then, of course, we haven't heard from him in over a year, almost 2 years. So my recommendation is that his probation is revoked.
All right. Mr.
And
Lee,
when he did call in, Your Honor,
Okay.
it was very sporadic. He would miss call-in reporting. I'd have to call him, try and track him down. So he wasn't even really good at even that. So
This is the part most defendants misunderstand. Probation isn't punishment, it's correction. The court's goal isn't to collect money. It's to reduce risk, treat behavior, and prevent repeat offenses. That's why the drug and alcohol evaluation matters more than the fine. It's about whether the defendant is safe to stay in the community when someone ignores treatment orders. The judge hears, "I don't prioritize the court's authority." And courts react very badly to that message. Even worse, this defendant admitted the violation. Once you stipulate, the court no longer debates guilt, only consequence. And consequences depend heavily on what mitigation you present next. A lawyer would already be negotiating immediate evaluation, proof of scheduling, voluntary treatment, maybe a short sanction instead of full revocation. But instead, the defendant walks forward alone, hoping apologies will replace strategy. And in criminal court, apologies without leverage are rarely enough.
Mr. Leesman, recommendations?
I do apologize for the forgetting of that. I'd gotten in another accident right around that time before it was October it was October before that February I had talked to him. So I'd been healing up and I forgotten about that drug and alcohol evaluation. And whenever we had talked, I had asked, he said I had to be here tomorrow to sign the paper. And I was asking, because I couldn't come from Port Aransas at that time all the way to Kansas to sign a paper. And I was seeing if we could do it like over like fax or, over like e-documents. So I didn't have to come in person all the way to Kansas to extend it for me to go do that drug and alcohol evaluation. But I do apologize for forgetting about that part. And I could get one done as like today, as soon as we leave here. I just wanted to get this warrant taken care of, but I understand. So I apologize.
This is where everything collapses. The judge is about to ask for a recommendation, and that's not casual conversation, that's sentencing advocacy. This is the moment a defense attorney earns their paycheck. You don't explain your past, you argue your future instead of proposing a plan, like immediate evaluation, reinstated probation, travel compliance, or even a short jail sanction. The defendant explains accidents, distance, and misunderstandings. Courts don't sentence excuses. They sentence risk. Judges want to hear structure, timelines, accountability, proof, and supervision. When the probation officer and prosecutor both recommend revocation, the defendant's voice becomes the only possible counterweight. And he doesn't counter. He confesses. Every sentence he speaks confirms unreliability instead of correcting it. This is the legal version of jumping without checking if there's water below. And the concrete is waiting.
Yeah, at this point, I don't know, I want you to become a productive member of society. I think the only way you can do that right now is that you become sort of deterrence and encouragement for other people to follow the orders of probation. So I'm going to revoke and remand you to serve your sentence. Good luck.
Wait, sir, how long is it? I came up here I came up from Texas and all right, sir. All right. How long do I have to do?
Whatever the original sentence was. I think we went over that, didn't we?
The original sentence was 6 months. I don't know if he's got any credit for time served on that.
Yeah, that's what it is, 6 months.
Or it was for a misdemeanor. I still have to do 6 months.
Yes, sir.
All right, sir. Okay. Is there? Or no, my bad. Is there any way to like that?
It's
never mind.
time to face the consequences. That's what's happening. State versus Colton Marceau, 23 CR 300025.
Yes, sir. Can you grab my phone right there, sir?
Sure.
When the judge says he wants the defendant to become a deterrence and encouragement, that's courtroom language for example making. Judges don't just punish individuals, they signal behavior to everyone watching probation. If one person ignores treatment orders and walks free, the system weakens. So the court restores authority through consequence. Revocation isn't emotional, it's institutional. The judge isn't mad. He's enforcing structure. The defendant didn't just forget paperwork, he disappeared, refused travel, skipped evaluations, and stopped reporting consistently. At that point, probation stops making sense. Supervision only works when someone cooperates with being supervised. So 6 months isn't revenge, it's reset. The court is saying, if you won't comply in the free world, you'll finish your sentence in the controlled one. And once those words land, there's no more negotiation, only processing.